Imagine opening your pay stub on a Friday afternoon, looking down at your hard-earned income, and realizing a collection agency just took almost half of your paycheck out of nowhere. Most people quietly assume that once a creditor wins a judgment against you in court, they have free, unlimited reign to start taking whatever percentage or dollar amount they demand from your earnings until the debt is paid off. They do not. Federal law draws an absolute, non-negotiable red line around your paycheck that a regular creditor is legally forbidden to cross, regardless of how much money you owe, how aggressive their collection letters sound, or what the underlying judgment itself says. The single most important number to know is $217.50. That is the exact weekly threshold protected directly under federal law. Once you understand the basic calculation behind it, you can verify your own pay stub in about 30 seconds, without hiring a lawyer or looking anything up. Under the Consumer Credit Protection Act, federal law caps how much can be garnished from your paycheck for ordinary consumer debts, like credit card balances, personal loans, or medical bills, at the lesser of two numbers: 25% of your disposable earnings, or the exact amount your disposable earnings exceed $217.50 per week. Whichever number is smaller is the absolute legal maximum they can take, not the higher number. The lower one, every single time. That single word lesser is doing an enormous amount of work in the statute, and it is the exact word that gets skipped over by anyone reading a garnishment notice too quickly. To calculate this correctly, you have to understand what the law actually defines as disposable earnings. It does not mean the money you have left over after paying your rent, groceries, car payment, or electric bill. Legally, disposable earnings means your gross pay minus only the deductions required by law, such as federal, state, and local income taxes, Social Security, and Medicare. Deductions for your 401k, health insurance premiums, life insurance, or union dues do not reduce your disposable earnings for this calculation, even though that money never actually reaches your checking account. This genuinely surprises almost everyone the very first time they hear it explained, because in day-to-day life, money going toward health insurance or retirement genuinely does not feel available. Legally, for this specific calculation, it still counts as part of your disposable earnings, which means the protected floor is based on a number that can be noticeably higher than what actually lands in your bank account. When you run the actual numbers, the protection becomes glaringly obvious. Say your disposable earnings are $400 a week. The first calculation is 25% of $400, which equals $100. The second calculation takes $400 and subtracts the protected $217.50 floor, which leaves $182.50. Because the law requires the smaller of the two numbers, the legal maximum a creditor can take is $100 a week, not the $182.50 sitting on the other side of the equation, even though that higher number was sitting right there in the raw math. Now look at what happens when your earnings are lower, because this is where people get genuinely surprised. Say your disposable earnings are $250 a week. 25% of $250 is $62.50. But $250 minus $217.50 is only $32.50. The smaller number wins again. The absolute maximum a creditor can touch is $32.50 a week, roughly half of what the flat 25% figure alone suggests. If your disposable earnings are $217.50 a week or less, the allowable garnishment drops to zero. A regular creditor cannot legally touch a single penny of your paycheck at that income level, regardless of whether the judgment against you is $500 or $50,000, and regardless of how many separate ordinary creditors happen to be trying to collect from you at the exact same time. It is worth sitting with how absolute that protection actually is. Below that specific income threshold, the answer for ordinary consumer debt garnishment stays exactly the same: zero. This simple math creates a massive divide between people who know the law and those who do not. Consider two workers earning $230 a week in disposable income. Person A gets a garnishment notice claiming a standard 25% deduction, assumes the court paperwork must be correct simply because it came from a judge or collection agency, and quietly allows roughly $57 to be taken out of every single paycheck going forward. Person B earns the exact same income, runs the two-part calculation, and realizes the real legal limit is only the amount above $217.50, which is just $12.50 a week. Both people have the exact same income and the exact same debt. Yet person A loses over 4 times more money than the law allows, simply because no one checked the math against the notice. Over the course of a single year, that weekly gap adds up to more than $2,300 taken from someone who legally owed none of it, purely because the original notice was never independently verified. Here is the trap that catches almost everyone, assuming this protection applies to every kind of debt equally. It does not, and the exceptions are aggressive. Child support and alimony run under an entirely separate section of the law. They can take anywhere from 50 to 65% of your disposable earnings, depending on whether you are currently supporting another spouse or child, and how far behind the payments actually are. Critically, that $217.50 floor does not shield you from family support obligations at all, even if your income sits right at minimum wage. Federal tax debts are governed by IRS exemption tables based on your filing status and number of dependents, which frequently protect less income than the standard rules for commercial creditors. Federal student loans in default can be administratively garnished up to 15% without a creditor ever stepping foot inside a courtroom or securing a judge's order first. An administrative garnishment means the federal government does not need to formally sue you or win a court judgment first, unlike a private credit card company. The wage withholding can begin from a federal notice alone, which is exactly why it catches so many borrowers by surprise. Furthermore, this federal baseline represents a floor, not a ceiling. Numerous states offer significantly stronger protections than the federal government, capping ordinary garnishment at lower percentages like 10 or 15%, establishing much higher protected weekly income limits tied to their local minimum wage, or exempting low-income earners entirely. Federal law sets the absolute bare minimum protection that every state must honor, but your specific state law may legally require creditors to leave you with considerably more than the federal baseline. Ultimately, executing this calculation correctly is your employer's legal responsibility. If a payroll department overwithholds from your paycheck, that represents a compliance failure on their part, not something you are expected to accept simply because a legal document exists. The limits are enforced by the Department of Labor's Wage and Hour Division, and the exact same rules apply to employers, collectors, and payroll departments across the board. Knowing the difference between what a collector demands and what the law actually permits is not about avoiding your obligations. It is about enforcing the exact boundaries the law puts in place to ensure you can still afford to live while managing your debt. Let's walk through that $400 a week example one final time so the stakes are completely clear. Someone who does not know this rule gets hit with a garnishment notice claiming $182.50, assumes it is non-negotiable, and pays it for months or years. Someone who knows the rule recognizes immediately that the legal cap is $100, brings the exact Department of Labor fact sheet to their payroll department, and instantly stops the illegal overwithholding before a single extra dollar leaves their account. The difference between those two outcomes was never about the size of the underlying debt or how aggressive the collection agency was. It was entirely about knowing that a creditor does not get to pick the larger number. The law requires the smaller one every single time, and $217.50 a week is legally protected no matter what happens or who attempts to claim otherwise.